Good day and welcome to Stratagem LP's Legal Podcast. This platform is designed specifically for legal professionals and law students who seek to stay abreast of evolving case law and critical legal issues. Whether in chambers, on a commute, or walking through your daily tasks, we offer you the convenience of continuing legal education at your own pace via our legal podcast. In today's episode, which doubles as our premiere, we delve into the issue of court jurisdiction and arbitration agreements. More specifically, we will be reviewing the case of UBA PLC versus TRIEDENT Consulting Ltd. Reported in 2023 Law Pavilion Electronic Law Report 60643 SC. A decision of paramount importance, wherein the Supreme Court provides crucial insights into Section 4 of the Arbitration and Conciliation Act 1988, Cap A18, Laws of the Federation of Nigeria 2004. This interpretation is particularly relevant given that Section 5 of the Arbitration and Conciliation Act 2023 mirrors its 2004 predecessor. Our review today will explore whether an arbitration agreement or an arbitration clause in an agreement deprives the court of jurisdiction over disputes that parties have agreed in their agreement to resolve via arbitration. We will critically analyze the legal reasoning, focusing on procedural nuances and their practical implications for the legal profession. To start, let's examine the key provisions of the Arbitration and Conciliation Act by comparing the 2004 and the 2023 frameworks. Section 4 of the Arbitration and Conciliation Act 1988, Cap A18 LFN 2004 provides as follows. Section 4, subsection 1. A court before which an action, which is the subject of an arbitration agreement, is brought shall, if any party so requests, not later than when submitting his first statement on the substance of the dispute, order or stay proceedings, and refer the parties to arbitration. Section 4, subsection 2. Where an action referred to in subsection 1 of this section has been brought before a court, arbitral proceedings may nevertheless be commenced or continued, and an award may be made by the arbitral tribunal while the matter is pending before the court. Section 5 of the Arbitration and Conciliation Act 2023 provides as follows. Section 5, sub 1. Notwithstanding the provisions of any other law, a court before which an action is brought in a matter which is the subject of an arbitration agreement shall, if any of the parties request, not later than when submitting their first statement on the substance of the dispute, refer the parties to arbitration, unless it finds that the agreement is void, inoperative, or incapable of being performed. Subsection 2. Where an action referred to in subsection 1 has been brought before a court, arbitral proceedings may be commenced or continued, and an award may be made by the arbitral tribunal while the matter is pending before the court. Subsection 3. Where a court makes an order for stay of proceedings under subsection 1, the court may, for the purpose of preserving the rights of parties, make an interim or supplementary order as may be necessary. In UBA PLC versus TRIEDENT Consulting Limited, the Supreme Court provided an authoritative interpretation of Section 4 of the Arbitration and Conciliation Act 2004. Since Section 5 of the 2023 Act is substantially in pari materia and ipsima verba with Section 4 of the Arbitration and Conciliation Act 1988, this case offers critical guidance for practitioners navigating arbitration disputes under the new framework. The court's judgment, delivered by Ogunwumiju, JSC, underscores the following. Initiation of arbitration proceedings. Section 4, subsection 1 requires that arbitration proceedings be initiated before a request for a stay of court proceedings can be made. Specifically, this means the first statement on the substance of the dispute must be submitted to the arbitrators. The court emphasized that this is not a mere procedural formality, but a substantive condition for invoking the arbitration process. The court's role in arbitration requests. The court clarified that even when a matter is before it, arbitral proceedings may continue while the court proceedings will be stayed pending the conclusion of arbitration. However, the application for a stay cannot be granted automatically. It must be supported by tangible evidence that arbitration proceedings have commenced, such as the appointment of an arbitrator and the filing of the first statement on the substance of the dispute. Arbitration trigger point. Importantly, the Supreme Court noted that the arbitration clause cannot be triggered merely by a party seeking to avoid litigation. In this case, the appellant's unilateral termination of the contract without first seeking arbitration was deemed inappropriate. The court reaffirmed that disputes, especially those involving technical matters like contract performance, should be resolved by arbitration rather than rushed to the regular courts. What then is the legal context of the intersection of arbitration agreements and court jurisdiction? It is well established in Nigerian jurisprudence that arbitration agreements do not oust the jurisdiction of the court, as the Supreme Court clarified in the case of AG Lagos State versus AG Federation, reported in 2003 LPELR 620SC, wherein the Supreme Court held that the Constitution's supremacy clause ensures that no law, including arbitration agreements, can contravene the court's jurisdiction. Specifically, Section 1, subsection 3 of the 1999 Constitution, as amended, provides that if any other law is inconsistent with the provisions of this Constitution shall prevail, and that other law shall to the extent of the inconsistency be void. Additionally, in Main Street Bank Capital Limited and Anno versus Nigeria Reinsurance Corporation PLC, reported in 2018 LPELR 44905 SC, the Supreme Court reiterated that the jurisdiction of the courts is statutorily vested by legislation or the Constitution and cannot be waived or conferred by agreement. This principle remains relevant today as we analyze Section 5 of the Arbitration and Conciliation Act 2023, which preserves the court's jurisdiction. Therefore, Where there is an arbitration agreement and an arbitration proceedings is duly commenced and the first statement of the substance of the dispute is filed, the court will grant a stay of proceedings upon an application unless the arbitration agreement is proven to be void, inoperative, or incapable of being performed. What then are the practical implications for legal practitioners? For practitioners, particularly those involved in commercial disputes, the UBA PLC versus TRIEDENT Consulting Limited case offers valuable lessons in the procedural and substantive requirements for invoking arbitration. The following steps are essential for parties seeking to enforce an arbitration clause. 1. Commence arbitration. The party seeking to resolve a dispute via arbitration rather than the regular court must firstly initiate the arbitration proceeding by appointing an arbitrator and submitting a first statement of the substance of the dispute before the arbitrator. 2. File for a stay of court proceedings. After initiating arbitration, the party should file an application in court for a stay of proceedings, referencing the arbitration agreement and the initiation of arbitration. 3. Evidence of arbitration initiation. Ensure that the motion for a stay is backed by concrete evidence, such as the appointment of an arbitrator and the submission of the first statement of the substance of the dispute to meet the legal requirements set out in Section 5 of the Arbitration and Conciliation Act 2023. By adhering to these steps, legal practitioners can effectively navigate the procedural landscape of arbitration, ensuring that disputes are resolved in the appropriate forum. In conclusion, this case reinforces the critical importance of following the proper procedural steps when seeking to enforce an arbitration agreement. The courts guard jealously the jurisdiction donated to them by Section 6, subsection 6 of the 1999 Constitution as amended, and will rather grant a stay of proceeding pending arbitration award, which the court can enforce, rather than declining their constitutionally donated jurisdiction. For legal professionals, understanding the intricacies of Section 5 of the Arbitration and Conciliation Act 2023 is vital to successfully managing disputes that involve arbitration clauses. We hope today's episode has provided you with a clearer understanding of the intersection of arbitration agreements and or arbitration clauses in an agreement and court jurisdiction. As always, we encourage you to stay updated on the latest legal developments to provide the best counsel to your clients. Thank you for joining us on today's Stratagem LP's Legal Podcast episode. Be sure to subscribe for more in-depth analysis of case law and critical legal topics. We look forward to having you with us in the next episode. I remain your principal host, E.B. Ochuma, Esquire. Thank you.